Good morning. Welcome, everybody. This is, it's nice to be back and having bar talk again. This will be the last bar talk for 2025. I'm Angela Armstrong, the executive director, and we're very pleased to have Jim Bowie join us today. But I'm going to go over a few things before we pass the mic over to Jim. So, as you can see from my slide, I have a few updates. I'm not going to get into all the upcoming programs. You can read those for yourself, but sorry, I'm admitting people as I speak here. In particular, hopefully most of you have seen that we are changing our membership year for the MSBA. So instead of crossing over partial years, like a 25, 26, we're moving to a full calendar year membership starting January of 26. And so the dues renewal portal, which normally opens in September, will now be opening on November 1st. We will send reminders to you. Just be on the lookout for that. But essentially, your membership that would normally have expired at the end of September is good now through December 31st. And I want to let all of you know that 2026 is also the MSBA's 135th anniversary. So we will be celebrating that next year at a lot of our events, Winter Bar Conference, Summer Bar Conference, and other things throughout the year. So please keep an eye out for that. We've got some exciting stuff that's going on. And now I'm going to turn it over to President Susan Fonts, who will introduce Jim. Thank you.
Good morning, everyone. I'm Susan Fonts, president of the MSBA. We are here today and excited to talk about what to do if a bar complaint is filed against you. Obviously, this is not an exciting topic for anyone, but good information to have. We have Jim Bowie, who is an attorney at Norman Hanson Detroit. He has been involved in a number of state and federal court cases. He has been a counsel of record in over 100 matters before the Supreme Judicial Court. He is serves as a mediator and arbitrator. He has also represented a number of people before the Board of Overseers. He served as a member of the Maine Board of Overseers. And so he has a lot of experience in this arena, and we are just so thankful that Jim is here today. I should also note that he recently had an extraordinarily handsome brand new grandson. That is a fact that he would like everybody to know for today's bar talk.
All right. Thanks, Susan. Just one quick correction. I haven't been a member of the bar or Board of Bar Overseers. I was a member, though, for a long time of the Professional Ethics Commission of the board. So lest I be accused of stepping on anyone's toes, it's the Professional Ethics Commission that I participated in. As Susan said, I've been doing this sort of thing for a long time. The bulk of my practice is representing lawyers in one form or another. And so over that time, I've had a chance to see what drives me nutty when I have people come in with bar complaints, and also have a feel for what bothers lawyers when they're faced with a bar complaint. I also called bar counsel to see what they had for ideas about things that they thought were either done well or done poorly when people faced with a bar complaint. So we'll go through that. A lot of this, I realize one of the difficulties with this is lots of times I'm preaching to the choir. Having said that, I think it's important for everyone to think these things through because if you practice long enough, you're going to have a bar complaint. I've had one, luckily only one. My partners might tell you that it's lucky that it's only one, but that's all right. But it will probably happen, and you need to know or think through how you would respond if that were to occur to you. I'm going to start with 3 basic rules, and then we're going to come back and go through these. But I mean, there's 3 things that happen if you get a bar complaint. The first is don't panic. The second is phone a friend, and I'll explain what I mean by that, but you need to involve someone else in it. And then the third, oddly enough, because bar council at least said that you'd be surprised how often this one doesn't get followed through on, you got to respond. So we'll start there. First, don't panic. If you get a bar complaint, no matter how well you think you are set up to deal with that sort of thing, you will find out as soon as you get the little notice through Barracuda or whatever from a bar council, you aren't prepared. You are going to be upset. You're going to be a little panicky. What I'm here to tell you is that most bar complaints are resolved with a dismissal or a dismissal with a warning, which is not discipline. So you should take a breath and realize that most of the time this is going to get resolved well, assuming that you don't make it worse by the way you respond to the complaint. You don't want to act rashly. You don't want to immediately dash something off, even if you think the bar complaint is silly. The fact that it may be frivolous it tends to make people act rashly. And I'm here to tell you that if you act rashly, you may find that it doesn't go away as quickly as you can, which sort of leads me to the second piece. Don't respond on your own, regardless of whether you are a solo practitioner, small firm, large firm, public attorney, whatever. Don't respond on your own. And I mean, this was something that was universal amongst the people that I talked to regularly, other people representing lawyers before the board, bar council, whatever. People really do need to get some perspective from someone outside, other than yourself, when the bar complaint comes in. That may mean that you simply talk to your partner or whatever. My recommendation is that you get somebody outside of your firm. Now, if you are in a firm setting, that means you need to report the bar complaint to whoever is in charge of those matters for your firm, whether it be a managing partner, if you have an in-house general counsel. If you're a small firm, a couple of people, you need to tell your partners or somebody else in the firm that it's happened. A variety of things will happen from that. For the most part, if you have insurance, you probably have free insurance coverage for an outside lawyer to help you in responding to the complaint. Though that coverage is a supplemental coverage on most, but not all, insurance policies. It usually is triggered without a deductible, and it usually doesn't make any difference in your rating or the chances of being renewed, if you will, with your carrier. It is coverage that is provided by the carriers to make sure that you do have somebody that you can help work with you, or somebody who will work with you to help frame your response. And so that you don't have to try to do it on your own and deal with all of the emotions that having a bar complaint filed in the first instance is going to cause to well up within you. If you call your insurance carrier or have whoever is appropriate at your firm contacting your carrier, one of two things will happen. They'll either tell you that you can go get your own lawyer, or they will give you the names of whoever their panel counsel might be. Some carriers are pretty loose about that they simply tell you that they would encourage you to talk to somebody independent, and they'll pay the bill. Other carriers will steer you somewhat to their counsel. The advantage of that is that you're dealing with somebody that works with the board on a regular basis. If you're dealing with panel counsel, if you go to someone on your own, they may or may not have experience in dealing with the board. And dealing with the board is different from other licensure matters. If you represent somebody before a licensing board, there are similarities to how a bar complaint is handled, but there are also some significant differences. So it helps if you have somebody who has at least some familiarity with the board. The other piece is that even if you think the complaint is frivolous and that you can respond to it quickly, there are a variety of little pitfalls that you may trip across, largely because if you think it's frivolous, you're not paying as much attention to it as you might if you thought that the complaint was more serious. While, as I said, most of the time these are going to get resolved with some sort of dismissal, they don't all get dismissed with a dismissal. And I will tell you that I've had several that should have been dismissed early on, but the response from the attorney caused it to become more complicated rather than less. And I'm sure we've all had clients who come in with problems saying to the lawyer, I thought I could handle this myself, but now that it's really started to go a little bit south, I realize I should have called you as the lawyer earlier. Well, the same process applies to you as the attorney who's facing a bar complaint. You're for example, you think it's frivolous, but in responding, if the complaint is from a client, you've got to figure out how you're going to structure that response without frustrating the client. Some bar complaints are a situation where the client really didn't want to file a bar complaint. They filed a bar complaint because they're unhappy with you, but what they want is not for you to be disciplined. They want you to do whatever it is that you're from their standpoint, you're not doing, you're not returning your phone calls, you're not following their instructions, what have you. And so having someone who's outside can help you keep your eye on the ball, so to speak, and dealing with that and figuring out, is this something that I can, where my response needs to be structured both to bar counsel and to the client, or whether you need to be worried that it's really bar counsel, who after all is the real audience for your response, who needs to be the focus for what you're going to do. That's a sort of long-winded way of getting into the fact that you've got to remember that when a bar complaint is filed, it ends up having a life of its own. Even if your client then withdraws the bar complaint or thinks they're withdrawing the bar complaint, it isn't over. Bar counsel, in a sense, owns the complaint and will need to resolve it. Now, that if the complainant withdraws the complaint, that's probably going to be a significant factor in how bar complainant views it. But it isn't as simple, or you can't think that it's as simple as having a client simply say, oh, I didn't mean to do that, I'm going to withdraw the complaint, and it's over and you don't have to respond. You do, and you need to remember that bar counsel will be a fresh set of eyes looking at whatever it was that created the complaint in the first place as well. As I said, I do recommend that even if you think it's frivolous and you do get someone else to look at the complaint, that you do try to go outside of your firm, or, especially if you're a small firm. It's really hard for somebody who's working with you as a colleague to give you a really good, dispassionate look at the complaint. They may not feel comfortable working with you, even though they'll say they are, in fashioning an appropriate response. And so you need to really, if you can, avail yourself of your insurance coverage, and then get an independent party to take a look at the complaint and help you formulate a response that's going to make sure that it gets done quicker rather than later. A couple of words on how this process works. Although there is some very limited pre-screening, the fact that a complaint is sent to you for a response simply means that if you take the complaint as as it was drafted without assessing credibility or what have you. It's almost like a 12b6 analysis that the complaint, if believed, could suggest that there was a violation of one of the rules of professional conduct. So remember that it doesn't mean that anybody has already felt that there's any merit to the complaint or what have you. They are simply looking for, the Bar Council is simply looking for additional information to figure out whether they should dismiss the case or whether it's going to require further investigation. When you prepare your response and send it in, that response is shared with the complainant, who can then respond. And you can actually ping pong back and forth in this process of complainant responding, the person against whom the complaint is asserted responding, complainant responds again, until it sort of either runs its course or Bar Council gets sick of the process and tells you to stop. They won't tell you that you absolutely positively can't respond further. But if you read the notices carefully, you will get an idea that, okay, Bar Council feels they've got enough information here and they don't need a further response in the ping-ponging back and forth. There are a variety of ways complaints can arise, and how you respond will differ depending on who the complainant is. If it's a client, in particular, you need to start thinking about, is this case over? If it isn't over, do I need to withdraw, not withdraw? And I'll come back to that in a minute. It certainly creates a potential conflict, and you're going to have to do a Rule 1.7 analysis. However, as I said, in some cases, the client, it really isn't looking to get you disciplined to get rid of you. They're really just looking for you to do something that the client doesn't think you're doing already. And you may be able to repair that process. Even that is particularly a case, however, where you need outside help to allow you to do that analysis in an appropriate way. Many complaints are brought by somebody who is outside of the attorney-client relationship. It can be the other side, it can be a third party. It varies how those arise. It can be a family member who's unhappy with something about the matter that you're involved in. It is not unusual in both civil cases, but particularly in family law matters, that the other side is really unhappy and files a bar complaint, largely because they're unhappy with the process generally, but it's easier to focus on the other side's lawyer than it is someone else. These types of processes obviously make it harder to do the Rule 1.7 analysis, and it may make a response a little more problematic. As I said, these responses are going to be shared with the other side, and particularly when the complainant is someone other than your client, that may require that you to provide Bar Counsel with information that is confidential as to your client. There is a process which allows you to file a full response with Bar Counsel, but also a redacted copy of that response that will go to the complainant, so to protect primarily attorney-client information. There are some limited circumstances where there may be other information that it would be inappropriate to share with the complainant. But you need to be really careful about that. You need to be able to explain to Bar Counsel why part of the response needs to be redacted. You need to think through how the redaction is going to appear, both to Bar Counsel, but particularly to the other side. In other words, there may be information that you can share, that your client would authorize you to share, which will clear up a misconception or just a confusion about facts. There are other times where it is clear that there's nothing you're going to do to resolve the dispute between the other side and your client. But it is nice to have somebody who can help guide you through that process about how we're going to respond, what information can we and should we share, what information shouldn't we share, and how to go through the mechanics of getting the redacted material to Bar Council.
Jim, I
Yep.
do have a question. From someone here. Is that okay to jump in right now?
Sure.
Okay. Can you talk about a fee arbitration petition filed by a former client that Bar Council then turns into a grievance complaint based upon allegations in the fee arbitration petition?
Sure. A fee arbitration proceeding obviously is a little different than what I've been talking about, which is a true bar complaint. Most of the time, those are handled really informally between a fee arbitration panel and the client. However, many times the allegations contained within the client's fee arb petition can be construed to raise issues that would suggest that there was a bar violation, a bar rule violation of some kind. My experience is that Bar Council doesn't routinely review those materials, but at times I'll be honest with you, I'm not entirely sure how they always come to Bar Council's attention. Bar Council can have access to fee arbitration proceedings, even though they are otherwise confidential. Whether it gets flagged by a participant or not is somewhat unclear to me. But the point out of that is that when you respond to a fee arbitration petition, you ought to give some thought to whether this could also give rise to a separate bar complaint. In some cases, the way the complaint gets through is that when the client calls Bar Council, it isn't clear whether they are seeking information with regard to a fee arbitration situation or whether they're trying to file a bar complaint. They may get information about both processes. My experience is that it is less likely that you're going to get a sua sponte complaint from Bar Council, although it can happen and does happen. It is more likely that the client will file a bar complaint as well as a fee arbitration proceeding, sometimes purposefully, sometimes because they think it's going to give them leverage on their fee arbitration proceeding, and sometimes simply because they don't understand the process and they're just filing whatever they can to try to get some relief. The point out of all of that is that fee arbitration probably isn't going to be covered by an insurance policy. Virtually all of them will tell you you're on your own for that, but you ought to keep in the back of your mind that those responses that you file may ultimately find their way to a bar complaint, and you ought to get maybe some help in navigating that if you have any sort of a concern that the allegations suggest a violation of the rules of professional conduct, or you're thinking that that's might be where it goes. I don't know whether that answered that question, but it is an important piece to keep in mind. When you're filing a response, it is important to be both candid and complete, especially if you think that you did violate a rule. Many times you may have violated a rule. One, it may not have caused any harm. Two, even if it did cause some harm, it may not be the sort of thing that requires discipline. Remember that discipline is focused on protecting the public and ensuring that lawyers be good lawyers. That doesn't mean that every violation results in significant discipline. So it's important for you to be candid. It's important for you to be complete. Bar Council is understaffed, and that is sort of a perennial problem in the office. They don't have a lot of lawyers. They have a lot of complaints, and they have a lot to do. which means that when you're filing a response, if there are key documents, if there's a docket sheet, if there's perhaps some correspondence, some pleadings, you may want to provide that to Bar Counsel with part of your response. In fact, I'd encourage you to do so. Bar Counsel isn't going to be able to spend a lot of time on their own doing independent investigation. They'll do some or may do some, but for the most part, they're going to rely on the information being provided by the complainant and the respondent. And so this is the response is your opportunity to frame the issue and to provide the factual background to allow Bar Counsel to do what you want them to do, which is dismiss the complaint. With that, and since I'd mentioned before that, I mean, the bar, a bar complaint once filed becomes, in a sense, Bar Counsel's and isn't subject to what the complainant necessarily wants in the way of a response. You need to remember that a prime audience is Bar Counsel when you're doing that response. Hopefully you did get somebody outside to help you tone it down. You want to be careful that if you're providing attorney-client information, that it is only information that is relevant to your self-defense. Just because there's a self-defense provision under Rule 1.6 to allow you to respond to a bar complaint doesn't mean that everything is fair game. And you can have a situation where if you get overly gushy about attorney-client responses, you may violate Rule 1.6 and create additional problems beyond if Bar Counsel were to feel that you went way beyond what was necessary simply to respond to the complaint itself. We're rapidly coming up on noon, which I think is the witching hour for me on this process. So if there are questions, I'd love to take them. If there aren't, I just finish with a couple of things. Remember, as I said, remember that just because there's a bar complaint filed against you, you need to take it seriously, but you shouldn't panic. It will work out all right. Two, you really, really, really do need to go get someone to help you with a response, even if you think it's frivolous, even if you think it's silly. Getting that fresh set of eyes is important. We all know that lawyers ought not represent themselves, and bar complaints are no different. And then lastly, you really do need to respond, and you need to respond fully and candidly. Remember that if you get in, if you denial is a real factor for some lawyers. And if you don't respond, that in and of itself is a separate and independent bar violation. So you might have a frivolous complaint, but if you don't respond, you get disciplined for not responding, even if the complaint goes away. So that's my story. I'm sticking to it. And if there are any further questions, I'd be happy to answer them.
Well, thank you, Jim, today for taking your time today to talk to everybody about this. If people have further questions, I'm sure they can reach out to you.
Absolutely.
But thank you, everybody who attended this. I hope that you found this helpful. And I just want to remind everybody that we have the Winter Bar Conference coming up January 28th through January 30th. So mark your calendars and hope to see you all there. Have a good day, everybody.
Great. Thanks.